Good afternoon to all. Namaste Bharat. Welcome to all for our next lecture in the Law Club series. I am Neeraj Shah, Associate Advocate of Law Chamber of Siddharth Morarka. We have a speaker today, Vishal Kanade, a practicing counsel in Bombay High Court, and he will speak on today's topic, Act of God and Force Measure. Before Vishal sir start, I just want to urge everyone that please maintain social distance and greet each other with the namaste instead of handshake. I request to all increase social distancing and reduce the emotional distancing and be safe everyone. Now I would like to request Vishal sir to speak on today's topic. Thank you.
Thank you so Thank you so much, Neeraj. I am delighted to be here with you all today. The subject for today's discussion is Act of God and Force Measure. I had an opportunity to address certain people on this topic, Force Measure on 13th April. That was essentially a group of people who were from the real estate sector. Today we have lawyers amongst us, so our discussion today can be based more on jurisprudential aspects. Uh, First thing that we can talk about is the relevance of this topic. We are now reeling under the impact of COVID-19. This is by far one of the most relevant topics which will come about after things start opening up. There is a staggered normalcy as we will find it. It's been an unprecedented event, and we will find in various cases that there are parties who urge and plead this issue of act of God, force measure in contractual relations. And this is something which will have an impact on a cross section of contracts, be it leave and license agreements, be it redevelopment agreements, or other documents of commercial type. We'll come across the definition and purport of these terms first. We have all come across in contracts a term which is broadly defined as the force majeure clause. Now, it is in this force majeure clause that you will find the term act of God. Therefore, act of God is essentially one of the circumstances that you can urge and use in relation to a force majeure event. Now, what is the definition of act of God? If you kindly see, there is a small note that I have circulated.
I will drop in the chat box.
Right. So we can be on the same page. It's there in the chat box, and we'll go through these definitions as have been laid down by the Supreme Court one by one. So if you see what is act of God in Mahadev Shetty's case, the Supreme Court has defined act of God essentially is operation of natural forces free from human intervention, such as lightning storm, etc. It may include unexpected occurrences of nature as severe gales, snowstorms, hurricanes, cyclones, so on and so forth. An act of God provides no excuse unless it is so unexpected that no unreasonable human foresight could have presumed to anticipate the occurrence having regard to the conditions of time and place. This appears to be the nearest approach to the true meaning of act of God. Similarly, another judgment of the Supreme Court, which is Patel Roadways, this is the second judgment in the note, broadly stipulates act of God will be an extraordinary occurrence due to natural causes, which is not the result of any human intervention and which could not have been avoided by any amount of foresight and care. A fire caused by lightning, but an accidental fire, though it might not have resulted from any act or omission of the common carrier, cannot be said to be act of God. Looking at these two definitions, one of the first things which will arise for our consideration is whether COVID-19 is an act of God. Now, this will be $1 million question in that sense, whether it is something which is entirely beyond the ordinary occurrence due to natural causes. What is
connected है अभी विशेष आवाज नहीं आ रही
Yeah, sorry, there's some disturbance here, so just request everyone to mute their audio so that there is no disturbance. So whether COVID-19 will be a act of God event is something which will arise for consideration for all of us. Now, consider this: if definitions are seen, it seems to indicate that this is an act of God completely beyond any of our control and outside human intervention. That is how it is being broadly defined. Uh, the answer to this really will be the $1,000,000 question. We'll have to wait and see, because there are many facts about COVID-19 in particular, whether it would fall within the ambit of act of God or not. Uh, we'll have to see. There can't be any definitive answer as of now. What we can do is consider how similar situations were dealt with, or how were they gauged by other jurisdictions. We have example of SARS in Hong Kong and in China, round about the same area where it originated, and what was done with that. Uh, Therefore, I think the crucial question for us will be whether this is COVID-19 in itself is an act of God, or a force majeure event, or circumstances or measures introduced by the government, such as lack of transportation or seizing of transportation activities, your labor not being able to come, various measures which have been put, essentially putting off a lockdown kind of situation. So whether it is virus or these measures which have caused this kind of event, that is where the rub of the matter would lie, and that is how we would have to see this. Uh, Now the impacts, as you will find, are already there. There's no gainsaying in the fact that this is something which will affect economic activity as a whole. And you have already situations where governments have taken various steps. For example, there are RERA notifications. There is a notification by the RBI, essentially to come out with a moratorium. So, in a manner of speaking, whether force majeure or act of God, this is something which has implications of putting this impossibility to perform. That is as far as act of God is concerned. We'll now come to what is force majeure. As I've said, act of God is one of the things which will fall within the ambit of force majeure. If you see the note, the next pointer or the definition as has been set out by the Supreme Court, that is in the judgment of Dhanrajmal Govindram, it essentially reads, if we can just go through this and we'll proceed further then. I hope everyone has a note. It's dropped in the box. So it's a small note, but it will help us be on the same page. The expression force majeure is not a mere French version of the Latin expression vis major. It is undoubtedly a term of wider import. Difficulties have arisen in the past as to what could legitimately be included in force majeure. Judges have agreed that strikes, breakdown of machinery, which though not normally included in this measure, are included in force majeure. And analysis of rulings on the subject show that where reference is made to force majeure, the intention is to save the performing party from the consequences of anything over which he has no control. This is the widest meaning that can be given to force majeure, and even if this be the meaning, it is obvious that the condition about force majeure in the agreement should not be vague. And there are other aspects of this. So,
Excuse me, may I disturb? Like many of us have not received any notes, so people are continuously asking in chat box to send the notes.
I have already dropped links in the chat box. Can you just check?
because these links have been dropped,
Please follow that link.
I think if you just click on it, the Word document will appear.
No, it's not probably. Can anyone just confirm whether they have received the link? See, they have not received the link.
Okay, I will do the needful.
All right. So
No, we haven't received it yet.
No, I haven't received.
all right. So just as a recap, what we've done is I've read out the definition of these two terms, that is act of God and force majeure as laid down by Supreme Court. Essentially, the summary or the summation is act of God is something which happens which is beyond any human intervention, some kind of natural calamity. Force majeure, on the other hand, is a event because of which performance on the part of a contracting party becomes impossible, which is something which is beyond his control. So the essence of the principle of force majeure is that a contracting party to a contract will not be asked to perform any act which he is not in a position to perform because of events which are beyond his control. So that is where we are at as far as these two terms are concerned. That is the judgments which have been set out. Essentially, a small part of the judgment where the definition is set is mentioned or reproduced in the note, but that is all that there is. If we can proceed, if the note is there. Now, the next thing which is going to come about is sections of the Contract Act. If I can just ask all people, this can be indicated in the chat whether this has been this is with you guys right now.
Yes, sir.
It's there, right?
Yeah.
All right. So coming to the Contract Act, you will find that term force majeure per se or act of God is not specifically set out. So what is the statutory provision, or what are the statutory provisions which will come into play when we talk about these two events? The two provisions in question really are section 32 and section 56. Can I, with everyone, if everyone is on board, can we go through section 32 if everyone has it? It's a small section. I'll just read 32 first and 56, and then we'll analyze these sections, because statutorily, it's only these two sections which will arise as and when we come across cases of force majeure or act of God. Now, the first aspect is the relevant provision number 1, section 32. 32 reads as follows: contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void. So what does this section really say? As we are all aware, this is that part of the Contract Act which deals with contingent. Yeah, I think.
Yes,
Yes,
sir.
can I continue?
Yes, sir.
Right. So we are on section 32 and 56. As I was reading, 32 deals with that part of the Contract Act which lays down what are contingent contracts. So the first part of section 32 really says contingent contracts to do or not to do anything based upon an uncertain future event cannot be enforced unless that event has happened. So if parties sit together for execution of a contract, which is based on the performance is based on happening of a certain event, unless that event happens, your contract cannot be performed. Uh, Second part, if you see section 32 of the note, if the event becomes impossible, such contracts become void. So if the contingency which is contemplated by the parties before they executed the contract becomes impossible for any reason, the contract becomes void. So this is one aspect of, or one species of frustration. Because the contingent event has become impossible of performance, the contract becomes void. This is the second part of section 32. Now let's see section 56. Section 56 reads as agreement to do an impossible act. First part, an agreement to do an agreement to do an act impossible in itself is void, right? The second part is what is relevant for our discussion today. Contract to do act afterwards becomes impossible or unlawful. A contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. So we have before us essentially two sections. The dichotomy is this: 32 talks about contingent contracts, which means that parties, when they sat together for formation of contract for finalizing the terms, knew about a particular event. It was within the contract, it was intrinsic to the contract. If that event does not come to pass, then the contract becomes void. 56 is the second part, or the other class of cases where parties enter into a contract and certain events occur because of which performance becomes impossible. That is something that the parties had no idea or knowledge about. They did not know about it, that something like this would come to pass. Act of war or a situation which is completely beyond your control, because of which a party is unable to perform its contract, right? So we'll appreciate the distinction because these are the two statutory provisions. 32 is parties knew about it, and the contract collapses because of the clauses which are part of the contract. That is where the event does not occur, it becomes impossible, then it becomes void. This is one class. The second class is, and in that sense, second class is something which we may come across. I don't foresee any contract where parties would have written, if there is a pandemic in 2020 February, only then this contract will go through. That won't happen. So 56 is what we'll deal with in majority of cases. Section 56 therefore contemplates something that is outside the contract, which happens because of which your performance becomes impossible. So these are the two statutory provisions that we have to consider. Now, coming to the judgments which have been passed on this, the law which has been laid down, you will find after section 32 and 36, 32 and 56 have been set out in the note. The judgment which is mentioned is Energy Watchdog versus CERC. This is 2017-14 SEC page 80. By far one of the most recent judgments which takes into account various previous judgments of the Supreme Court, judgment authored by Justice Nariman. And it gives a reference to various cases in the past. One of the earliest cases is Satyabrata Ghosh, that is AR 1954, Supreme Court, page 44. And the Supreme Court in this judgment essentially has laid down what does the term impossibility really contemplate. If I can read, the second paragraph of section 56 has been adverted to, and it was stated that this is exhaustive of the law as it stands in India. What was held was that the word impossible has not been used in the section in the sense of physical or literal impossibility. The performance of an act may not literally be impossible, but it may be impracticable and useless from the point of view of the object and purpose of the parties. If an untoward event or change of circumstance totally upsets the very foundation upon which the parties entered into their agreement, it can be said that the promisor finds it impossible to do the act which he had promised to do. It was further held that where the court finds that the contract itself either impliedly or expressly contains a term according to which performance would stand discharged under certain terms, the dissolution of that contract would take place under the terms of the contract itself, and such cases would be dealt with under section 32 of the Act. If our frustration is to take place before the contract, it will be governed by section 56. So the essential part of impossibility is not actual, may not be in the sense of actual physical or literal impossibility. It will be something which makes the performance of the terms of the contract practically impossible, or the object of the contract is defeated. That is where we are at, and this is something which will come about in various cases. So as we will see, any kind of temporary difficulty in terms of either finances or any situation in terms of the market forces, the market conditions, in itself is not something that a party can rely on for the purposes of urging a case of force majeure, right? It is something which attacks the very basis of the contract, the underlying object between the parties, and if that object gets lost, then it becomes impossible to perform, and then section 56 will come about. That is where the meat of the matter would lie. Now this takes us to what happens in terms of what is the effect of impossibility. And what are the consequences, right? As far as effect of impossibility is concerned, if a party says that party is unable to perform, if that stand is taken, because one of the aspects which we must bear in mind is that ultimately force majeure per se being in the realm of contractual law, every case will have to be looked on a case by case basis. You will have a situation where a contract itself provides for what are force majeure events. It is open to a party to exclude some classes of force majeure events and include only a few. So that kind of classification can also be made. A party can very well say that a contract will remain suspended so long as certain conditions continue to last. And if that is a contract entered into between both the parties, as long as that situation of uncertainty or the situation mentioned in the contract subsists, a party can be said to be exempted from performance of his obligations. But that will be temporary. That will be something which will last only till the situation does not change. So, for the purposes of ascertaining in our leave and license agreements, our redevelopment agreements, what is how do you come about whether force majeure will apply, whether this is an act of God? First thing that we would have to do is to go through the terms of the contract which we have entered into between the parties. What are the events of force majeure? Uh, what parties have said would constitute event of force majeure, whether it would be temporary or permanent. Uh, and it is only after examining these individual contracts with their individual terms, one would have to come about with a case of whether there is force majeure or not. Needless to say that as far as force majeure is concerned, the burden will be entirely on the party who asserts it to show how there has been a force majeure event.
I have a question, Mandeep here. So, can this COVID situation that we are currently on, can it be taken as an force majeure event?
So, Mandeep, can I just request one thing? I'll just go through 3 or 4 more aspects on this topic, and then we can go to question answer. Hmm? Right. So, we were on what is the effect of force majeure, and that is something which we as lawyers will have to be cautious about. That is because when we come across cases where there are parties either in the scenario of a redevelopment agreement or otherwise, when people come and say that we want to urge a case of force majeure, what we need to bear in mind is what are the consequences. So one of the consequences of taking a stand of force majeure is that the contract automatically unravels. You are permanently exempted from performing any of your obligations, and you cannot be forced to perform that obligation because it has become impossible. So one thing we would have to see is because it is automatic as opposed to let's say a rescission of contract on the grounds of breach, there is automatic unraveling. The contract comes to an end. Uh, we would therefore have to see whether the case which comes before us is some kind of temporary difficulty which a party is facing, which a contracting party is facing, or whether the impossibility which a party alleges is such that the substratum of the contract itself is lost. Uh, One of the judgments which you'll find, which I came across, just as an illustration, I'll indicate. This was a case of Delhi Development Authority, Delhi High Court, where there was a tender for the purposes of construction of buildings. Now that contract was entered into, and later it was found that the area where the construction was to take place was ultimately classified as a ridge area on which construction could not take place. So in these circumstances, after the parties had canvassed their submissions, ultimately the Supreme Court found that the purpose and object of the contract and the tender was construction of buildings for a particular purpose. Because this underlying theme or underlying object of the contract is now incapable of being performed because you can't make any construction on the ridge area. Therefore, the plea of impossibility was upheld. So, as far as cases that may come across, this is something that we'll have to bear in mind to see whether it is a temporary kind of phase, whether a redeveloper or a developer says that I cannot pay my rent for the purposes of alternate accommodation for the time being because of these 3-4 months my work has come to a complete standstill. I cannot continue with any construction because my laborers have gone. It's essentially a temporary kind of a situation. So whether you would want to take that kind of stand there and then, or whether it's a case where the performance has just become impossible. So that is where the our analysis will come into being. Another aspect which arises is that this plea of force majeure, something that not arise if the party asserting it is himself or herself in the fault. You cannot take advantage of your own wrong, and therefore if you yourself have been negligent of a certain course of action, then section 56 or frustration will not be a panacea that you can rely on to say that it is beyond my control. So one would really have to see the conduct of the party. The cases of self-induced frustration that because of your own action, whatever they may be in terms of your liquidity, as an example, if you have been negligent or your business practices have been not up to the mark, then you can't really successfully plead this kind of case. So ultimately, we come down to the same aspect that this is something which will depend on facts of each case. The Supreme Court in Satyabrata Ghosh case, which we have discussed earlier, essentially has said that for the purposes of Indian law and the Indian Contract Act, 32 and 56 is what will have to be seen. This distinction, because frustration is one genus. The species are section 32 and 56. It's a self-contained, it's a positive law. As far as 56 is concerned, it will arise under the provisions of Contract Act. English law in that sense will not be specifically applicable. So that is where the law rests at the moment. The judgment which is set out in the note is an instructive judgment on this point. That is something that we can go through to get a grip on the subject and interplay between 32 and 56. Ultimately, it boils down to facts of each case and the clauses which are entered into the contract. It will entirely depend on that. That is where act of God and force majeure would come about. Broadly, these are the various heads that would arise. Now, as far as COVID-19 situation is concerned, because one of the reasons why this topic was selected in that sense was because of its relevance, as we have discussed before. It's been an unprecedented situation. This is something which is bound to arise. And it is in that background that these are 4 or 5 prominent headings of the subject. What are the consequences, what it means, and how it will depend on case-by-case basis. So the judgments that I've said, there are more. I can share the research that has gone into this in terms of chronological arrangement, but by far the important things which I thought were necessary for all of us to be on the same page are there in the note. We can circulate that, and broadly this is where we are at. If there are any questions, we can start with that, because
Yeah. I request everyone, is there any question, then please drop them in a chat box. Accordingly, Vishal sir will give the answers.
Sure. I am Vishal Mandeep here. So I am in practice since last 17 years. So I just wanted to know that while you have very nicely covered section 56 and I think 32 is what you mentioned, right? So that's a good note. But considering the current situation, the COVID-19, can it be construed as a force majeure?
Yeah, can you hear me now?
I can hear you now.
Yeah, all right. So, as I said, really the question is whether COVID-19 is a force majeure condition or the effects thereof, whatever
Yeah.
measures the government has implemented. That would be something which would constitute a force majeure event. So, the answer is, as far as COVID-19 itself is concerned, there is much to be found out about the virus itself. I think as lawyers, what we'll come across is the measures which have been implemented to stop the spread of this virus, whether they tantamount or they amount to force majeure events. Now, answer to that question will really depend on what is the obligation that was cast on a party and whether that obligation has become practically impossible or the object is lost. So that is why it will depend on the facts of each case. But broadly, uh,
Yeah.
you have a lockdown for about 40 odd days, which may be extended further. For any industry is ultimately based on labor. If your labor is not available, uh, one
Yeah.
would have to see whether it's a temporary kind of a situation, whether you yourself are at fault, and what has been your past conduct. So
No.
combination of these three aspects. Just as a word of discussion, we can talk about. Ultimately, any party who wants to claim that there is a force majeure event is obligated and obliged to inform the other side on the
Correct.
very first possible occasion to say that this is the stand that I'm taking. It is not possible for us to perform, and that is where we would have to see whether the stand which is taken and the advice that we give to our clients would be whether this is a temporary phase accommodate. We would ask for some accommodation based on these situations and circumstances, or whether you would say now one way or the other it's become impossible for me to perform. So that is where our scrutiny, our examination will come about.
No, so like if the tenant is basically is not able to come down to the premises and he's saying that I cannot pay the rent because of the force majeure, I cannot come to the premises and do my work, right? So can he take that stand and say because of this I'm not able to come down and I want an exemption in the rent because of force majeure?
So, as we have seen in redevelopment agreements, even much before COVID-19, because of the situation in the real estate market, you had a situation where there were so many redevelopers who were unable to pay rent to their tenants, to the
Correct.
society members, so on and so forth. So, essentially, it will boil down to the same situation where you would have to sit across with the counterparty to the contract and try and work it out. Whether you will be able to see, if you say that there is force majeure, that means the contract effectively is over. It's unraveled entirely. So that's
Yeah.
the call we would have to take. One request, Neeraj, if I could make,
Yeah.
questions are put in the chat box, it will be easier.
Yeah, I just,
Otherwise,
Mandeep sir, just drop the message, whatever you have a question, sir.
Sure. I'll do that. I'll do that. Thank you. Thanks, Vishal.
thank you.
Yeah.
Vishal, sir, there is a one question.
Yeah.
The commercial lease will be governed by the contract or the TPA.
Sorry, come again. The
Commercial lease will be governed by contract or TPA.
See, as far as commercial leases are concerned, you have Transfer of Property Act, in which you have broad definitions and obligations that arise, and you have remedies as to what happens if your conditions of lease are not satisfied. So, in that sense, it would depend on your lease document. It would probably be an amalgam of both, and this is a defense that a person may raise depending upon the facts of each case. But it would really depend on the terms of the contract, be it a commercial lease or even a residential leave and license agreement. If the licensee says I'm not able to pay for the time being for during this temporary phase, essentially you would be asking for a novation, a change of contract, changing of deadlines for payments, so on and so forth. And it would depend. I mean, if a party wants to take it as a ground of breach of contract, breach of term, then he would take it in that sense, and both sides would have to be heard essentially on what went about.
Okay. So there is a one more question.
Yeah.
Can the leave and license agreement invoke force majeure and not pay rent of commercial premises? Even notice there is mentioned in agreement to terminate the agreement.
So you will find in leave and license agreements at times there are provisions. There's a clause on force majeure
Force
itself.
majeure.
So what is that clause? Does the clause talk about any kind of temporary hold on performance of obligation to pay your rent during a certain phase, whether that has been mentioned or not? And take a case where there is no force majeure clause at all in a contract, leave and license or otherwise. The issue would then be that you would have to still fall within the ambit of section 56. If there is, because not mentioning of force majeure or act of God in itself will not be determinative if otherwise you satisfy conditions required under section 56. So it would depend on facts of each case.
There is a question. I own a shop, have given on rent. Will it I get rent from the tenant or can be he refuse to pay?
Sorry, come again.
I own a shop, have given on rent. Will I get rent from the tenant or can he refuse to pay?
See, per se, temporary difficulties which a person may face because of COVID or any other reason for that matter, it can be 100 different things. There won't be any dilution of your contractual obligation because essentially it's a temporary kind of a situation. So a party will not be able to refuse. You will find in many cases there are provisions where if there is breach, there is opportunity given to remedy that breach, right? So those kind of clauses are also there. So it would depend, but broadly from the judgments that we have seen, any kind of temporary kind of situation, because it can be anything. COVID is just one of such examples. You will have a situation where, for example, oil prices, they are at their lowest now. Many people would have entered into contracts probably about petroleum and crude kind of products on the basis for certain bandwidth in the price. So today it can be said that those contracts have become frustrated and section 56 would come into play just because there is a temporary phase of difficulty.
So there are many questions are coming. What I can say, I will request everyone, they can drop the message in the Telegram group. According, I will forward to you, sir, and we can give the all answer by the till 2 or 3 days.
So I have a very general question to ask. It may not be related to the subject matter currently. May I just put the question to Vishal, sir?
So Neeraj is a moderator, he'll have to decide.
Yeah, he's sure, anytime.
All right. So my question. I mean, thank you for a very informative session today. It was indeed like an eye opener for all of us present here. My question is very. It's a simple question which it states that if you were I'm Miss Nilomi Popat. I'm a final year graduating student. And my question to you is that if you were the 2020 graduating batch, like a graduate, and if we were in the middle of such a crisis or a world war like situation, what will be your plans for the future? Like, what would you do for the future in this case? Would you start your independent practice or join, let's say, your father's chamber, or continue as an intern at a law firm or something, or anything else? If you could just advise.
I think the question emanates from something which may affect all of us. Let's be, I mean, in a candid kind of way. When the court reopens, it's not going to be life as usual. All of us will have a very different kind of situation to face in terms of how work was done and how things were. It will take time for things to come back. So we are in uncharted kind of territory now. It's
Yes.
too early to say anything. I think we will have to wait it out and see how things unravel.
Yeah.
On a general
No,
basis.
sir, generally, if saying that if we take you back in time when you were a graduate of your year, and if such a thing would have happened in that moment, what would you do? I mean, what would be your advice for students like us, or what would you have done for the future?
It's a hypothetical question for me, but broadly, as I said, we would have to wait and see how things are. You can't commit yourself to, as a student, as a graduate student wanting to join the profession, you can't commit. That's what I feel, but that's a personal thing. You'll have to wait and see.
Thank you so much, everyone. I Neeraj Shah, Associate Advocate of Law Chamber of Siddharth Morarka, and the Law Club, the Telegram group, would like to take this opportunity to place on record our hearty vote of thanks to Vishal Kanade, a practicing counsel in Bombay High Court, for the lecture on Act of God and Force Majeure. For your very thought-provoking, interesting, and current scenario like COVID-19 was also nicely covered. And I also look forward to have at least one lecture by you every month, if possible for you, sir.
See, with the current scenario, we have time.
Thank you so much.
Yeah.
Thank you so much.
Yeah,
Thanks.
it was a tremendous upgrade of a lawyer's knowledge, and we are grateful to the speaker and the audience. We hope to empower lawyers and serve the nation. We also thanks to all the law club friends for the enormous cooperation in the organization of this event. Be happy and be safe. Thank you so much for everyone.
Thank you.
Yeah, just give us the link of the Telegram, no, please.
I will share everything. Yeah. Okay.
Yeah.
Thank you.
Okay. Yeah, thanks. Thank you.